Hello, TikTok. Here we are with part 6. I defended myself from what I reasonably believe to be an aggravated felony assault by statute and definition by domestic terrorist police organization members under color of law. Petitioner was defending life and liberty from a serious injury and arbitrary unreasonable seizure as guaranteed, protected, and immunized by the United States Constitution's preamble, 2nd and 4th Amendments. Said violations and criminal acts being committed by heavily armed persons acting under color of law in their official capacities as City of Sioux Falls police officers. The state of South Dakota filed criminal felony assault on law enforcement officer charges and filed the Part 2 habitual offender information on 2 pending cases. What's double jeopardy? I raise constitutional challenges to that. No person shall be twice put in jeopardy of life or limb or liberty for the same offense. I was convicted of that escape maliciously for a crime I didn't commit, and they want to enhance and impose more penalties based on a wrongful conviction. And they won't let me present my evidence to the public jury for a hearing because they know they're liable. The courts appointed Caleb Paulson to assist Gomez in his defense against criminal accusations in the case. Gomez raised self-defense immunity claims, demanded speedy trial from Caleb Paulson, and I even submitted my own jury instructions on self-defense and several other things. Turn that back on, please, baby boy. Thank you. Turn it on. I demanded speedy trial from Caleb Paulson and communicated explaining he would not be negotiating any plea deals and directed Paulson to retrieve the files provided to Mark Cady and prepare for trial. Paulson continued to advise and demand the petitioner to plead guilty and accept 30 years in prison for defending himself against law enforcement officers. The petitioner terminated the attorney visit and directed. I got up and left, screaming at him, "Do your fucking job. Speedy trial demanded," over and over as I was leaving. Paulson, in retaliation, moved for delay against petitioner's objections. Exhibit 2, Document 3-8. Judicial Officer Bradley Zell granted a delay, being deliberately indifferent to the Sixth Amendment right to a speedy trial. Paulson then moved for an order discharging him from assisting me, falsely claiming that I wanted a new lawyer. I never wanted a new lawyer. I wanted him to do his job, and I didn't want him to delay nothing, further depriving petitioner of Sixth Amendment right. Paulson falsely stated that petitioner requested Paulson to resign, as did Bradley Zell. Bradley Zell is lying too. There was no irreparable breakdown in communication. I communicated my desire to present evidence in a jury trial and speedy trial. Paulson is a military active duty transport security gunner for the United States military, impersonating defense lawyer while performing surrogate prosecutor's duties on behalf of the state in order to secure guilty convictions without a trial, and supports police officers and refused to argue against their domestic terrorist organization. He had a personal conflict of interest. He didn't want to present a defense justification against fellow armed terrorists acting under color of law. The court appointed Manny DeCastro of DeCastro Law, who also moved for several delays, falsifying the motions and deceiving the courts, stating he spoke to me and that he obtained my voluntary waiver and consent to delays. Petitioner never voluntarily waived any of my rights and continually demanded speedy trial. DeCastro then moved for a delay before Robin Howman. I objected. DeCastro moved for a psychiatric evaluation, delaying trial for 11 more months. He had cause for concern for my mental health because I was accusing him of fraud. He wasn't concerned because I had just suffered a taser dart and 5,000 bolts into my head. If he would have said that, it would have been more believable. He wasn't concerned for my mental health. So anyways, trial was delayed for 11 more months, resulting in the petitioner filing Gomez versus City of Sioux Falls, 22-41 Gomez versus City of Sioux Falls, 22-4147, Appendix 1, Document 4, in the United States District Court for the District of South Dakota. The state's Judicial Circuit Court Officer, John Saugen, brought the complaint of DSD 22-4147 into the state's record after petitioner made an oral motion for a dismissal of the charges for failing to afford a speedy trial and removed DeCastro as counsel The judge removed DeCastro as counsel, appointing Bo Blowen at MinnehahaCounty.gov. Now, Bo Blowen got promoted after he secured that involuntary conviction, no contest plea. Petitioner pled no contest to simple assault on law enforcement officer and filed a motion to withdraw plea in state of South Dakota versus Gomez. The courts denied, and petitioner appealed. Bo Blowen at MinnehahaCounty.gov has recently filed a motion to be discharged from duties and failed to file the appeal. Exhibit 3, Document 1-2. Petitioner filed one state habeas corpus filed June 10, 2022 in the Minnehaha County Judicial Circuit Courts under Gomez versus Michael Matson and the Attorney General of South Dakota, case number 49 CIV 22-1930, Appendix H. Now, one of the Attorney Generals said that the state would be prejudiced because I was raising defenses against the habitual offender statute allegations. But they weren't prejudiced when they brought it up against me, and they want to talk about it then. But when I try to talk about it with them, it's prejudicial. It don't make sense to me. So that's why this whole court thing to me doesn't make no sense. It's fraudulent. It's fake. It's criminal. It's corrupt. It's terroristic. And it is domestic. And your taxpayer dollars are funding it. The domestic terrorist training, that's why I was asking that officer on his live stream where he received his domestic terrorist training. Where did they train him to kidnap people? Who provides the domestic terrorist and kidnapping tools, the handcuffs, the transport vehicles, the human smuggling vehicles? Taxpayers are. I'm opting out of paying taxes because I do not fund domestic terrorist, human trafficking organizations. You know, they like to point out the border and say, oh, this smuggling and human smuggling and this and that. Those are migrating. Them people are migrating willfully. Human smuggling and trafficking is kidnapping and moving against your will. That's what police departments, Department of Corrections, that's what they are. They're domestic terrorist organizations. So I filed the Michael Matson and the Attorney General of South Dakota and one federal habeas corpus simultaneously with the prior mentioned state habeas. See Gomez versus Michael Matson, Attorney General Mark Vargo in the U.S. District Court for the District of South Dakota, 22-4076. Other directly related habeas corpus, Gomez versus Dooley, DSD 421 CV 04177 and 421 CV 04085. Petitioner has demonstrated the futility of exhausting state remedies in several instances. So there is no exhaustion of remedies. You don't have to exhaust remedies when you can demonstrate the futility. This was a futile act. And it gave grounds for Roberto Lange to say, oh, well, you can't because you did it after a year. Well, I was doing all this within that year, so I kept it going. So it's futile to do all this. Officers are taken together. Petitioner establishes the elements for Monell liability by presenting several separate and distinct documented cases as a result of the constant disregard to the constitutional protections and their obligations surrounding the 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 14th, 16th Amendments. The whole entire Constitution, they disregard it. Officers of the courts and judiciary have enacted rules that in effect contribute, condone, promote, praise, and encourage the malicious prosecutions, false imprisonments, kidnappings under color of law, contrary to the United States Constitution, actionable under 42, 1983, and Title 18 U.S. Code 241 and 242, criminal deprivation of rights, and further violating the state of South Dakota's Open Courts Clause, shuttering the doors of the courts to the existing judicial remedies for injuries in person, property, and reputation, namely the doctrine, policy, practice, and or custom of granting summary judgment and qualified immunity prior to trial is akin to a criminal court granting an acquittal before a jury is presented with evidence at trial. They don't do it. Acquittal may be granted after evidence is presented in a jury trial and after a jury renders its verdict, and qualified immunity, which is a privilege and immunity that is only available to police officers and licensed lawyers or judges and does not and has not been an equal privilege or immunity for all citizens, classes of citizens, and corporations, is an unconstitutional doctrine, practice, custom, and policy. It's criminal, corrupt, and illegal. It's unlawful, which contributes to the continued violation of rights, which include but are not limited to the First Amendment right to redress of grievance, Second Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, and so on and so forth. We'll be back. I need more followers to be able to go live.